Welcome to The Jury's Still Out, a show highlighting and discussing all things having to do with law, trials, and juries. Your host is Mary Griffiths, a litigation consulting expert who has overseen thousands of cases in state and federal courts, and is a jury correspondent to discuss trial matters and media strategy as it pertains to jury selection and courtroom performance. This is The Jury's Still Out.
Hi, welcome back to The Jury's Still Out, where we talk about all things trial, law, and juries. I'm very excited to have my next guest on. He has been in commercial litigation for a long time. He's the head of his litigation section at his law firm, Kane, Russell, Coleman, and Logan. Please welcome to the show, Mike Logan.
Thank you very much.
Mike, so commercial litigation covers so many different areas. What is the most, as we're in the pandemic, most popular areas that you are seeing right now?
Well, for us, anything that touches real estate, I would say, is probably our biggest area right now. And I mean real estate in the sense that you're a restaurant and you're operating in a lease, or you're a developer of a shopping center, or you're a retail outlet, or you're a hotel. All of those businesses, which are sort of our bread and butter clients, are all being impacted and have issues that relate to their ability to stay in business, their ability to earn income, their ability to pay their rent, their ability to pay their notes. We represent a lot of banks. So one of the things that we're gearing up for is the next round of workout litigation, which is a broad term, meaning anyone who's incapable of paying their debt as it comes due. Now, what can we do as a bank, as a landlord, as a lender of any type to help that entity get through this period of time in a way that when they get to the other side, they're still a good client, still a good customer, still a good tenant, paying their bills, rather than, well, we've run them into bankruptcy and now everybody loses. Because, the other hot spot for our firm and for all of the country is bankruptcy filings. Mm-hmm. They are soaring. Mm-hmm. And so this workout area, which is pre-bankruptcy and can be done by either litigators or bankruptcy lawyers, or so a combination of both, is definitely a hot area. Mm-hmm. And one that we saw back in the 90s, mm-hmm. When the last crash, the early 90s, and we had the workout lawyers in our office probably were busy for 5-6 years following that.
Wow.
And so there's a lot of people predicting that this will be very similar.
So we're in mid-2020 right now. How has your practice changed from March 2020 to about right now?
Well, first of all, everyone's working from home, mm-hmm. which we never thought litigators could do. So that's right. Mm-hmm. That's been a significant change. And I think a couple of other things. Obviously, there's no trials. Right. And as a consequence of that, there's no urgency, because mm-hmm. lawyers tend to work on deadlines and work on the things that are proceeding to trial first. And mm-hmm. that's one way you prioritize. So right now, mm-hmm. everything is on the back burner. Mm-hmm. As a consequence of that, a lot of the plaintiffs in these cases have stopped pushing them forward because they're not going anywhere. Mm-hmm. And so there's been a general slowdown, I would say, in litigation across the board. I even surveyed, we've got 40 some odd litigators in mm-hmm. our firm. And I did a quick survey in anticipation of coming here just to see what was happening across the group. And similar to my own practice, that's what most of them are seeing. Mm-hmm. Zoom has certainly come along at an interesting time. We're doing more and more depositions and mm-hmm. hearings and mediations by video conference. Mm-hmm. I think that'll be a long-term impact on the business of the law. Right. Positively and negatively, mm-hmm. so see that differently. But as I was saying again before we started, our clients are still hiring us, matters mm-hmm. are still coming in. Fortunately, they're still paying their invoices. Right. So most of those things that we were a little concerned about just as a firm, and I guess across the industry, haven't materialized. But the cases themselves are definitely proceeding at a much slower pace.
You bring up a great point about like the virtual depositions. What do you think are the pros besides sort of a cost expense that you're not having to travel as much? Tell me what you think the pros and cons are of these virtual depositions.
Well, I don't know if there is a pro beyond the cost, but the cost is a big pro because in all cases, and for the time that I've been practicing, over 35 years, people have been talking about the cost of litigation and driving people out of the courthouse, people not capable, even businesses that can't really afford to fight a legitimate fight today because of the cost of doing it. So when you have the opportunity to take a deposition at a third of the cost or half of the cost,
Right.
I think that is important to the client. From the negative side, I mean, we're lawyers, and a lot of what we're after is the words that a witness says, but a lot of what we're after, and you being the jury psychologist standpoint, you know that as much as communicated non-verbally as verbally. So
Right.
over a video camera, on a Zoom camera, you're losing, in my opinion, you're losing almost all of that. There's still the ability to look into a screen and look at someone's eyes. And so there's some of that still, but just the feeling of the room, what's happening in the room, sometimes the tenseness of the room as things are happening, I think you're losing all of that. And which excuse me for interrupting, but I think that's one of the reasons why on a go-forward basis, when we're able to do anything with a choice, I think smaller depositions, less important fact witnesses, things like that, will continue to be done by Zoom for cost reasons. And I've even had clients tell me, let's not take the plaintiff's deposition by Zoom. Let's wait till the court will allow us to do that in person. And so I think that's how it's going to be going forward.
Well, and that's a great point about sort of the art of advocacy. You realize how much of the art is when you're in the room, when you're reading people, as you just said, reading your witnesses and finding those pauses and finding those moments where even though what they said was substantively correct, maybe you're seeing something in the witness that's telling you different. And that's an art part that I don't know if Zoom could ever, or any of the mediums like that, could ever really convey.
And I think it's subtle, but I think that people influence the decision makers through their nonverbal content as well. So always in a jury trial, lawyers are doing things non-verbally that they are hoping to influence the jury's view, whether it's nodding their head or shaking their head or any number of non-verbal cues to hope that a juror or two is keying in on you and how you feel about that.
Right.
Same thing happens with judges. I mean, there's a multi-party argument we had on Friday in a complex construction case, and when you've got 3, 4, 5, 6 lawyers arguing over video, the judge isn't able to, while they're watching you argue, see me doing whatever it is I'm doing to try to say to the judge that argument is incorrect because I'm not able to verbalize it.
Right.
If I was in the courtroom and the lawyer made an argument that wasn't a good argument or that I didn't feel like was a good argument, I might do the same thing with a judge that I would do with a jury, just to let the judge know that's really not correct. What she's saying is not correct. Now, I'll get my chance later to verbally express that, but I just think that's an important part of advocacy that we lose by video.
Right. And, even from the juror's standpoint, I've done some online stuff during the pandemic, and they even sort of miss the idea of, I like to be in the courtroom, I like to see what's going on, and I want to experience the figuring out myself. So for them, even though convenience, now we're talking about virtual trials and that being a potential, I've talked to some jurors who've served on juries and they were like, you know what? There's nothing like that experience about being in the courtroom, it evolving in front of me. I get to see it. And I, just as a small war story, I had one trial lawyer, and I was like, that's genius in some ways, and that's kind of wow. He would wear like 3 watches on his wrist, kind of going to your point, to make people, instead of focusing on what the opponent is talking about, the jurors would be like, why is this guy wearing 3 watches?
Sure.
And then he would change it every day. So sometimes 3, sometimes 2, you never knew.
Right.
So, I mean, there's something about the energy of the room that virtually you lose.
Well, and I think part of it is a show, part of it is theatrics. Juries are now tuned into to the theatrics of the law, I think. And, if you have a witness who's doing badly in a deposition, you try to do something in the deposition to change what's happening. In 20 years ago, lawyers might have been more aggressive in some of those tactics than they are today. Judges don't let you.
Right.
And as a profession, we shouldn't engage in some of those behaviors.
Right.
But as simple as needing to take a break or getting up and going and getting a cup of coffee, which distracts the person from whatever they were about to say. Little things that just may or may not change the course of the case, but it's those opportunities that you hope as a lawyer that you've learned over the years that are impacted. But the part about the jury that I thought was interesting, what you just said, is how all jurors, people who are going to serve on a jury, rarely want to be there in the beginning, but when they've finished, and I'm sure you've spoken to many jurors afterwards, they've loved the experience afterwards. And it's because they're involved in it and they're part of it and they appreciate and they learn from it. And I don't think the video trials are going to give you any of that. You're now a robotic, it's like doing an e-jury now. I mean, a lot of people, some lawyers are now using these online valuation services or online mock juries and things to try to value their cases. Well, that just can't replicate the in-person experience, in my opinion.
Right. So for the pandemic, kind of going back to this idea of what type of questions are you getting more and more of these days? Is there a particular theme to some of these questions? Are your clients asking certain things?
Are we talking procedurally or substantively?
Substantively.
Well, I think the biggest issue that I imagine every law firm is addressing is there any recourse for the shutdowns? Are there insurance claims that can be filed? Does my insurance cover this? I mean, everyone who runs a business has some form of business interruption insurance. And we all think that if our business is interrupted, that we have insurance for that. But very rarely do clients ever use this insurance. And so now we have everyone in the country who is being shut down saying, well, I have insurance for that. And, that is going to run through the courthouse over the next several years as to what is or is not covered by business interruption, what is force majeure. Is a pandemic force majeure? Probably not, but what if the governor says you can't open? What if the government shuts you down? So without any question, that's the number one question I think almost all lawyers are being asked is there any way to get any relief? And of course, if you follow the insurance side of this equation, their response is if we really had to pay those claims, we would be out of business because we didn't write policies and collect premiums based on the idea that the entire country was going to shut down. So I'd say substantively, that's probably the biggest question. And then we get into the more nuanced or more specific issues dealing with landlord tenants. A lot of my clients in particular are retail, restaurant, hospitality clients. And in the restaurant world, I mean, half of them, almost all of them, are were shut down for a period of time, and they still owe rent. Offices that are shut down, they still owe rent. Malls that were shut down. There was a big article yesterday that came out where Simon malls is aggressively pursuing their mall tenants for rent payments from retail companies that were not open and had no revenue. But their lease doesn't say if you're not open, you don't have to pay us. So there's a lot of legal issues in that, and we're on both sides of that issue as a law firm because we represent a lot of developers. We have a large litigation practice, but we also have a large transactional practice, and a lot of that transactional practice is in the retail and restaurant and hospitality segment. So we actually see it from both sides. We have developers and landlords asking sort of the same questions. And those answers are unclear regardless of which side you're on right now.
It's interesting that you say that because I've talked to some people and like what is happening now in the summer of 2020, not an issue in January of 2020, but some of the mock jurors that I've spoken to, the analysis is that are restaurants doing enough? Are companies doing enough? Like, so there's going to be a different paradigm that jurors are going to be looking at. And this is going to be something new that we're going to sort of the pebble, this is going to be a long-term effect of what did your company do? Did they do enough? What did they know?
Well, that's a good segue into to what I would say is the second most frequently asked question for me in my practice is that. So if you're a restaurant and you have a single employee who's diagnosed with COVID, what do you do? And I've had those calls. What do we do? Do we have to shut down? Do we have to report it? Does OSHA require us to do something specific? And we have some lawyers in our office who specialize in OSHA, and they can't keep up with OSHA's changing, well, they can, but figuratively, with their changing views on this. OSHA has gone from one extreme to the other on how even they think this should be addressed. But to that specific question, you're a restaurant, you have one employee who's tested positive for COVID. What should you do? What are you obligated to do? And maybe to your point, more importantly, what happens if you do or you don't do one thing or the other? Do you have liability for that? Let's say you decide to, everyone would say, well, you got to come in and thoroughly clean and use the commercial cleaning services. That's a no-brainer. That's what everyone's going to do these days. But are you going to shut down otherwise? And let's say you don't shut down, and a week later you have 5 employees who now have COVID. Did they get it from the restaurant? Did they get it from, they were out protesting? Did they get it because they were at a Trump rally? I mean, there's almost no way to know where it came from, but the law is imposing on employers this obligation to take reasonable measures. And to your point, what is a reasonable measure for COVID? Is shutting down reasonable? Is shutting down for 12 hours and cleaning reasonable? Do you have to close entirely? And then we have clients in the meat packing industry, not Tyson, which is the one that's been mostly in the news. But in that situation, those companies are working elbow to elbow, on the line. And a large number of people are coming down with COVID. And should those companies be held responsible is what people are asking. And of course, the government continues to talk about whether we're going to offer some immunity or liability immunity for this because it's something that no one caused. It's a natural disaster type thing. But that legislation hasn't been passed. And if it is passed, is it going to be retroactive now to March? Because there's hundreds of lawsuits already on file. What happens to those?
Well, and going from the flip side, I've heard individuals say, well, I don't know, I need my job. I don't know if I would go and tell my employer if I had it because I wouldn't want to have any sort of ramifications against me. I mean, so there's sort of like the individual, their interest versus a group interest, which is something new that I've been hearing about from the employee perspective.
Well, or even take something as simple as, a Cowboys running back who's outed, by someone in the media for having it when that could harm his career.
Right.
And should that be made public? And should he have to disclose it? And then what does the Cowboys organization have to do in response? And all the college teams, their players are getting COVID. It seems like a higher rate than the normal population. I don't know if there's any statistical evidence of that, but it seems like if you have a 30-person or 50-person roster and you're having 10, 15 people get COVID, you're statistically high numbers are getting it. Why is that? But what's the obligation of the schools? And what's the obligation to the sports programs? And can they play football in the fall?
Well, and how is HIPAA going to be impacted by this? I mean, what are my rights of confidentiality of what I have to disclose, what I don't have to disclose? This is going to have, it seems, just a ripple effect down the line of issues that I don't even think we're all thinking about that are going to happen.
Sure. So I go into my office, and as we partially reopened, and I have to check in, with the person with the thermometer to take my temperature and write my name down and make sure that I'm wearing a mask and that I'm okay to enter a law firm that I own. It's a strange feeling. And yet we're a small piece of this for the employers, like getting back to restaurants and such, which they can't function without their employees. And by definition, it's a closer, environment. These restaurants serving people and having interaction with people. So it really is going to, I think, be a long-term litigation boom arising from this that we haven't even started to see yet.
Do you think that there's any particular trends that you're starting to think that we're going to see, like the boom, more so in one area than another?
I'm not sure. I think the whole issue of liability for an employer is going to be the biggest one because lawyers are going to be very creative in arguing that an employer should have known and should have done something more than whatever it was they did. And it's almost like any other lawsuit where something has occurred. So they have the benefit of it having occurred, and now they argue, well, what should you have done differently? So those lawsuits are always problematic. It's like a product failure. Once the product's failed, we know it's failed. And now you can look back and say, well, you should have known it was going to fail. And maybe you should have.
But then from the juror's perspective, if you're an employee and you've worked for maybe a mom and pop restaurant or a different type of store, and you've seen firsthand sort of the hardships that they have had to undergo and undertake, and maybe the company doesn't, survive, that particular perspective is going to also be infiltrating these types of cases, because the sympathy, if you're an employee who's lost their job and you really wanted to have the job at this company and seeing it that they didn't do anything, but yet the economy and all of this stuff made them implode, that's going to be a different type of perspective added to this group.
Yeah, I think so. And we had a mediation 2 weeks ago for one of my largest non-public client, a privately owned but large client. And, one of the things I argued or talked about to the mediator as a mitigating factor in the settlement was the fact that our client had just laid off or furloughed thousands of workers. And shouldn't your client take that into account? Shouldn't they have some level of empathy for the fact that whatever happened in this particular instance that you were mad at them about, maybe you should tamp that down a little bit in light of the fact that they're struggling for their very existence. It didn't seem to work so much in my mediation, but I do think that in a jury setting, a jury could easily be sympathetic to a restaurant chain or any employer really that suffered dramatic consequences of this. But then you'll get into the question of how much of that's admissible and what's the judge going to let you say, because it's sort of the opposite of the argument, well, you can't tell the jury they're a big, rich company. Well, now you can't tell the jury they're a big, rich company that's suffered tremendously as a result of this pandemic.
Right. But I think as jurors, as people just living through this, we're going to either A, know of someone, B, it happened to them.
Sure.
So that is going to be a life experiences that's filtering into this conversation. So kind of going on that note, you've been a litigator for a long time, and that's a good thing. I know, like, whenever I talk to people, they're like, please don't say a long time. And I'm like, no, this is a good thing. What have you learned from jurors? Is there something that really, as you go through your practice, you're like, man, now I get it. That's something that's significant.
Well, you're probably a better person to ask that question of. And by the way, I've learned this from one of my partners, that when you're plus 30 years in the legal business, then you're a 30-plus year lawyer. No matter how many more years beyond 30 it becomes.
Right.
So I'll adopt that. But, I think the issue from what have I learned from juries is what we all thought or think we know, and that is I think jurors want to do the right thing. I think they think they're doing the right thing. I think that they are all shaped by their life experiences. And I think as lawyers, we probably sometimes don't do enough to understand where the jury's coming from and adapt our presentation to that, because we're sometimes lost in the mechanics or the facts of a case that are very, to us, one way or the other, very clear, and any right-minded person should see it that way. But just like this social unrest that we're seeing, everyone sees it through their own lens and through their own life experiences, and through conversations they're learning that people had life experiences that no one ever knew they had. Everybody
has a bias, and I think that if you introduce that to the jury when you're talking to them and not make it some sort of a curse or something shameful, we all do. It's just, does your bias, how would that impact this case?
Sure.
Maybe you're better served on a different jury, and that's completely fine. But going to your point about, I do think for the young lawyers, their art of advocacy or their ability to try a case in front of jurors because they're not having the opportunity.
Right.
I think we're really starting to see how that's impacting the legal community because they just don't have they haven't had the experience. So what would you tell a young lawyer who wants to try cases, something that they could do to learn to become better? Because it's happening.
Right. Well, we have young lawyers in our office, and I enjoy trying to teach whatever I can to young lawyers, and particularly trial lawyers, and tell them things that I think are good or bad, and they take from it whatever they will.
Right.
But, the biggest thing I think you can do as a young lawyer is try to observe as many other more senior lawyers as you can. Every time there's a jury trial at the courthouse, find some time to go watch it. And, you're not always going to learn things that are good. You may learn things that are bad. Oftentimes the lawyers that are trying the cases today, no offense to those lawyers in particular, but the cases that are getting tried are often the sort of routine fender benders and things like that tend to go to trial more often because the insurance companies or whatever are not willing to pay them. The complex cases with maybe better lawyers, at least better in the sense that they're higher dollar and more money involved, like business cases that we're talking about. When you see those cases go to trial, those lawyers have probably been to trial many times less than the trucking or auto lawyers that we're talking about who try cases frequently. So where are you going to learn the most from? Are you going to learn it from a complex business case with lawyers that don't see the courtroom very often, or from lawyers who are picking juries, several times a year? So there's a lot to be learned in both situations. But, I think the thing what I've always tried to teach, and I think I learned it early on in watching some senior lawyers even take depositions, is they get too mechanical, I call it, too wedded to their outline, too wedded to what they pre-planned before they got there without reacting to what's actually occurring in front of them. And a lot of times a client, a witness, a plaintiff on the other side gives you exactly what you needed to win your case, and you weren't listening because you were planning for the next question you'd already written down. And so best advice is just to be an active, participant, not a canned participant, and try to be more authentic and more into the moment. Now that's what I've always done, and people will say, well, you're a fly by the seat of your pants sort of lawyer. And there is some truth to that at one level, but I am prepared. I'm prepared for what's going to happen. I just don't script what's going to happen.
Right.
And to me, that makes me more able to do what I'm trying to describe. I don't know if I've done that very well.
No, absolutely. And it kind of goes to what we were talking about in the beginning. It's sort of the art of reading the room. If you're too much looking at your outline, you're forgetting that I may have just found my moment. Because if I'm just thinking about this, it's intuition at its best.
And the other thing which plays into your business as well is whenever we pick a jury, we try to figure out who's going to be in charge, who's going to be the foreperson, who's going to be the presiding juror of that jury. Because if you don't know that going in, you're handicapped. And, whether you get it right or not, you can probably, if you've done this long enough, you can probably narrow it down to one or two people. Say either this person or this person is going to be the presiding juror. So how does that influence how I'm going to present this case? In our last trial back in March, we had a police officer, and we were certain that this police officer, because of his demeanor and the way he answered questions, was going to be very assertive in the courtroom. And so we paid particular attention to him during the trial. What was he doing? When he took notes, what was he taking notes about? What was happening at that point in the testimony that made him write something down or not write it down? And again, you don't know whether those are the right things, but intuition and experience tells you that this is something you need to be doing. And that's what makes trials fun and interesting. But after this trial, when we interviewed the jury, I'll say that one of the things that I found fascinating with that particular jury is they didn't like our client, but they were really going to rule for us anyway, which I've always told clients going into trials, that trials are a lot about likability. They have to like you. They have to trust you, believe you, and it all comes down to, a lot comes down to likability. And in this particular trial, they didn't really care for our clients, but they believed them anyway.
They believed them.
Even though they didn't like them. So that was a little bit of a twist for me.
It's why we can learn so much.
Right.
From juries all the time.
Right.
Mike, thank you so much for coming in. We really appreciate it. A lot of good information here. We hope that you subscribe to the channel and I'm such a Gen X. I don't even know all of the things that you need to do, but we hope you do it, and please return to our next episode of The Jury's Still Out. Thank you.
Thank you.
Thanks for watching The Jury's Still Out. To learn more about Mary Griffiths or our guests today, check the description below. Don't forget, we'll be here every other week of the month with more incredible trial stories.